Today's business update is about our lawsuit against the Department of Housing and Community Development. We have filed our motion to reconsider. My name is Doug Quattrochi. I'm the Executive Director of Mass Landlords. For those of you who don't know, during the pandemic, there were about 151,000 applications for rental assistance that were timed out. The state and its agencies said there weren't enough documentation. There wasn't documentation submitted to go along with these. And of those, 47,000 were actually lost to state supervision. And that's a big problem because we're worried these households were actually evicted and these landlords went out of business. Here to speak with us about this today is Mass Landlords Legislative Affairs Council Attorney Peter Vickery.
Thank you, Doug. Yeah, we wrote the brief and filed it in December of last year, 2021, and then went to the John Adams Courthouse in Boston to argue it. And that's a long round trip. I live in Amherst in Western Mass, so that shows, I think, our commitment to helping landlords and renters get the rental assistance they deserve and are legally entitled to. Unfortunately, for Mass Landlords, our members, and for the public interest, I think, Judge Cowan, who's the judge in this case, allowed the department's motion to dismiss. So to be clear, no trial yet, no evidentiary hearing. At this threshold moment, the judge allowed the department's motion to dismiss. So we have filed an appeal, a notice of appeal, and we've also filed, as of last Friday, I'm sorry to be clear, we've served on the other side last Friday a motion for reconsideration. And when they send their opposition to us, we then file that with the court. So appeal and motion for reconsideration. And the motion for reconsideration comes with 4 affidavits from the public. One from a landlord, 2 from renters who were unlawfully denied rental assistance. And we also have an affidavit from a researcher at Brown University, and I'll explain why in a moment. Our argument is that the court essentially made 3 mistakes, 3 errors. First, the public records law says expressly that the government has the burden of proof if it wants to withhold records from the public. But what the judge did in allowing the motion to dismiss was basically flip that burden so that the burden fell on us to disprove the government's case. Second, the court didn't seem to understand how we would use the public records that we're seeking. The court seemed to think that we would need to out or dox individual renters in order to show disparate impact. And that's not the case. And that's what the affidavit from the researcher shows, we hope. And third, the court didn't see the public interest in the massive number of timeouts. Readers of our newsletter will recall that in one 4-month period, November 2020 to March 2021, the department rejected, or the RAAs rejected, something like 68% of applications for no apparent reason, and they couldn't tell anybody why. So that's something that the public has an interest in. And we're going to continue to litigate the case on behalf of owners and renters, and we're doing that because of the commitment of members. So thank you, Mass Landlords members, for your support in this. In particular, the property rights supporters whose funding makes that work possible. Thank you so much.